Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. Thank you to all Committee of International Conference of Management and Muamalah 2021 who is for conducting this seminar. Okay, my name is Mohamad Aiman Madya. So today I would like to present to all of you my research paper entitled Detailed Analysis of Syariah Court Evidence Law on Digital Document as Evidence and its admissibility in court proceedings. Okay, this is overview of my presentation today. The first one is introduction. The second is the position of digital document under Islamic law. The third one is the reported cases involving the digital document as a method proof in Malaysian Sharia court. The fourth one is the challenge and suggestion where admitting the digital document as evidence in the Malaysian Sharia court. And the last one is conclusion. Okay, for the introduction, the digital document is one of the new form of evidence, particularly for this. This is because, in general, the use of digital document in court can prove or convict a person in a case and also acquit an innocent person. Not only that, with significant change in time and facilities, digital document has begun to become one of the main reference materials for HFA and have begun to gain place to replace old-fashioned documents that rely solely on pen and technology. Right? According to the one of Fattah also, the committee also have begun to accept digital documents in daily matters such as bill payment, money transfer, job application, and others because of faster and time saving. However, the definition of digital document according to Islamic law is still does not have a clear place in terms of its position as a method proof in court proceeding. On the other hand, the issue of the acceptance of digital document in Sharia court also is still not fully discussed in detail, as legal practitioners are still less exposed to case related to it. Therefore, this study will analyze the concept of digital document as evidence under Islamic law by referring to the provision of the Sharia court evidence Federal Territories 1997 and how far the admissibility of a digital document in the Malaysian Sharia court. Okay, the first one is the position of digital document under Islamic law. Okay, the researcher have referred to Islamic Sharia law, which is the Sharia court evidence Federal Territories 1997, to explore the position of the digital document under this enactment. And the findings are summarized in the table 1 and below, which is the section 3 of this enactment, which is the section explains the concept and definition of document. And the researcher noted that the document is included in this section. And the section 49, and for this section, the digital documents are included in the funding distribution category. The last one is section 23, which is that involving the use of digital document in the Sharia court should be accompanied by expert opinion to maintain the credibility and validity of the evidence. Okay, the next one is the reported case involving the digital document and the method proof information. Several cases the reported in the Sharia court. For example, Muhammad bin Abdul in Madya type of case claim, exception claim, and this case, in this case, type of the document used as student type of case claim is done for court corporation. That's what is the of the Alias Aiman and Adnan Abu. Type of case claim is very corporation application. Type of the picture of the okay, the next one is the challenge where admitting the digital document as evidence in Sharia court. Generally, the jurisdiction of Sharia court is very limited compared to the civil court. This is because in the Sharia court there is no specific provision that provide for the use of this document in comparison with the civil court, which is there has the specific provision related to the use of the document as evidence. Yes, the Signature Act 1997 and others. However, the digital document is accepted as evidence under Malaysian Sharia Court based on the Section 3 and Section 49 of the Sharia Court Evidence Federal Territory 1997. And there are several challenges of accepting digital document as a main approach. For example, is the admissibility of evidence, which is digital document as evidence without witnesses and experts, as well as the clarity of the evidence. This is because it is intended to convict a case, especially in criminal case such as Kalwak case, where further evidence is needed to reinforce the evidence that will be submitted to the Sharia court. Not only that, according to the Dujana and the Fakaramdi also, the issue relating to admit the document as the conventional means or digital means is a forgery or falsification. This is because in the advancement of science and technology, the originality of fake of a photograph and the result of recording sound or image or video can be made by other person because of due to the irresponsible attitude or individual who are low in moral and religious value. The researcher would like to put forward some suggestion and improvement trying to the document as one point of proof in the Sharia court. Therefore, the scholar and dedicated expert in the field of evidence as well as researcher must discuss to form a definition of digital document according to the Islamic law and its admissibility as evidence in the Sharia court that must be clarified and refined. This aim to further detail the concept of the document from the perspective of Islamic law and its implementation for state in court. This is because previously, as we know, that in the Sharia code there is no specific provision in regard to the use of this document as evidence. Therefore, this suggestion maybe can be made. And the second one is more the challenge that will be faced when using the digital document is its specification. In the Sharia code also, there is no specific provision for an offence related to the common forgery. Instead, it is confined to the offence of contempt of court. Therefore, the Sharia law practitioner also should refer to case the common forgery and cases related to the use of the digital document as evidence into the court and how the civil court handle this case. By referring to the civil court also, the Sharia law practitioner should know how it can be applied and how it can be implemented in the Sharia court to combat cases related to the document forgery and the use of the digital document as evidence. As an conclusion, the description of digital document form can be used as one of the new form of evidence, specifically to be applied in the Sharia court. This is because from the finding of the research conducted, the researcher found that there are several provisions regarding the use of this document as evidence, such as Section 3, Section 49, and Section 33 of the Sharia Court Evidence, Federal Territories 1987. And the researcher also found several cases regarding the admissibility of this document in the Sharia Court, such as the case of Muhammad bin Abdul against Mutalib and the case Halijah bin Abdul against Abdul bin Baharuddin, and the marriage application case of Siti Adira Suhaimi and Adnan Abu. And also the researcher also put forward some challenge that Sharia law practitioner will face when handling case related to the use of the document. And at the end of the study, the researcher also takes some suggestions for improvement regarding the acceptance of digital document in the Sharia court. Okay, that's all for me. Thank you and Assalamualaikum.